Welcome back. In 2018, voters in Florida overwhelmingly passed Amendment 4, restoring voting rights to most felons who have completed their sentences. In 2019, the Republican legislature set out to undermine the amendment by requiring those felons to also pay court-ordered fees, fines, costs, and restitution before being able to cast ballots. The ACLU and other groups sued the state and federal court, arguing the law is nothing more than a poll tax designed to keep minorities from voting. Julie Ebenstein was the lead attorney for the ACLU, who argued the case last week before a federal judge.
Amendment 4 actually said nothing about financial obligations, and I think that's something that has gotten lost along the way quite a bit. What it says is that before you have your rights restored, you have to complete all terms of sentence, including parole and probation. So it's very specific about parole, it's very specific about probation. The phrase at issue was what all terms of sentence means and when those terms of sentence are complete. So a lot of people are off paper, as they call it. They finished parole, they finished probation. They're no longer under any jurisdiction or supervision of the criminal courts in Florida or any other criminal court. They just have this debt obligation that remains ongoing. A lot of our clients never expect to be able to pay the amounts that are owed, some purely costs and fees and some with convictions back to the 70s. So they would basically be serving, when it comes to voting rights, a life sentence. They would never be able to rejoin the electorate and participate in democracy, oftentimes because of a conviction decades ago. And that was really the concern for us.
There was, though, I do remember when the amendment was being proposed and when the supporters of it were campaigning, they would often argue that it would include full restitution. You know, can they be, if the public was given the impression that full restitution was a part of the amendment, even if it was not in the actual language, does that not bear some weight?
So actually one of the experts for the state argued just that, but was unable to show that the voters as a whole either believed that the Amendment 4 must have included this or that they wouldn't have passed Amendment 4 had they known that it's unconstitutional to require someone who cannot afford to pay in order to vote. So that was one of the arguments that the state made, and you know, we're awaiting the district court's decision, but it certainly wasn't one that we felt was well supported by the evidence in the case.
So let me just stay with this for just another second. Let's say that I've been harmed in some way, and the person who has done the harm to me, either by stealing from me or by causing me exorbitant medical bills, finishes his term, finishes his probation, but yet still owes me or owes my business some financial restitution. Why shouldn't I be made whole before that person's life can be made whole?
Well, you should be made whole, and the idea here is whether somebody can vote or not doesn't affect their ongoing obligation to pay the person who was a victim or who had a loss related to their crime. That obligation remains, and as soon as they're able to pay that, they are required to pay that. But just to clear one of these things up, oftentimes people owe debt collection agencies fees. People owe large companies some sort of restitution or other obligation. So you know, one of the complications that came up over the course of trial is that debt collection agencies tack on exorbitant fees, 40% of whatever's owed when they're collecting money from somebody. So even somebody who's attempting as best they can to continue to pay their LFOs could very well be paying into the debt collection company without actually pushing down their debt. So in a sense, thus far in Florida, debt collection agencies have been prioritized above somebody who's owed restitution in many instances. So that, you know, it wasn't just a question of disenfranchising people who are unable to pay. Another issue in the case, and another constitutional claim that we made, is that the system is such a mess that the state of Florida can't even tell people how much they owe, how much they have to pay, and whether they're eligible to vote or not. We found, even with our clients who have legal representation, just a total inability of any state actor to tell us what the debt that they must pay was. Some of our clients have, one of our clients, Ms. Riddle, who is a great grandmother, has convictions from when she was 17 years old, and those records no longer exist, or they're in storage, nobody can find them. It's putting people through an Alice in Wonderland situation, trying to figure out the record keeping of Florida in order to just determine what they owe and who they owe it to. So the problem is bigger than just people being, first, that they shouldn't be required to pay for the right to vote. Second, that they can't afford to pay for the right to vote, and they shouldn't be discriminated against on that basis. And third, Florida can't even tell them what they have to do to regain their right to vote, leaving them in this very precarious position where, to exercise their right, they would have to take risks about registering if they might be incorrect. It puts all voters in really an unfair and unconstitutional situation.
Is there a racial component to this? Do
Yep,
you
we
find
also
that
brought
minorities are disproportionately affected?
Yeah, we also brought an intentional race discrimination claim because there are disparities in who is disenfranchised. Before Amendment 4 passed, Florida was way behind every other state when it came to disenfranchisement, to the extent that 23% of the Black voting age population in Florida was disenfranchised because of a conviction, and 10% of the overall voting age population in Florida was disenfranchised because of a conviction. That's mind-boggling when you think about it, that 1 in 5 African-American adults was disenfranchised before Amendment 4. And to me, Amendment 4 was so significant because it was the voters themselves saying they wanted to do away with this. They wanted to bring their fellow citizens into the democratic process and into the electorate, and wanted them to be able to exercise their rights. When you look at what the legislation, SB 7066, did, it would have disenfranchised, we were able to identify with Florida convictions at least 750,000 people who still had outstanding LFOs. So that is a deep cut into the group of people that Florida citizens decided they wanted to bring back into the electorate.
I know that it's been referred to as a poll tax. There have been some who have pushed back against that because of the racial connotations. They think that it's offensive to describe that. But what you're outlining now, and you actually claim that it was a deliberate effort to suppress African-American votes?
So we have two different claims. We do in fact claim that it's a poll tax in violation of the 24th Amendment. And we also claim that it's intentionally discriminatory. The racial disparities in both disenfranchisement in Florida and in the criminal justice system were well known to the legislators who passed this law. The effect of the legislation was well known. And yes, our claim is that they acted intentionally and in the face of these well-known facts, knowing that would disenfranchise a disproportionate number of African-American voters.
Well, I guess that's the question is, was this a feature of the system or a bug? In other words, was the system designed to suppress African-American vote, or was it just simply a byproduct of an antiquated system that it disenfranchised votes?
In our view, it was a motive. So the requirement is not that the legal requirement is not that you show that it is the only motive or that it's done with anger and animosity or anything like that. Our claim is that it was a motive in passing this legislation. I think it's difficult to support the idea that it's simply a bug because it's a fact that was well known to legislators. It was presented over and over and over again by returning citizens, by advocacy organizations, by other people who spoke at the legislature. It's a choice to ignore that tremendous disparity, and making that choice itself is problematic. So I think it's hard to say that it wasn't known or that it was just accidental. It was certainly a choice that legislators seem to have made.
Ebenstein said she believes they will have a ruling in time for the November election. We'll be right back.